23 DCCR 0167. Ms. Joseph is on probation for assault of a peace officer. There's a motion to revoke, and will she waive the formal reading of the motion?
Yes.
Ms. Joseph, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 11th of 2023 for assault on a peace officer, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you were arrested for the offense of driving while intoxicated with a child under 15, June 21st of 2025. And is that true or not true?
Yes, ma'am.
True or not true?
True.
Thank you. Count 2 and count 3 both allege that same offense, same date, different children. And again, are those true or not true?
True.
Count 4 alleges that you were arrested for the offense of resisting arrest or search or transportation June 21st of 2025 in Orange County. And is that true or not true?
True.
Count 5 alleges that you failed to remain in Jefferson County, Texas as directed, and that you were in Orange County, Texas on June 21st of 2025. And is that true or not true?
True.
Count 6 alleges that you were at a location other than your residence at approximately 10:17 p.m. on June 21st of 2025. And is that true or not true?
True.
Count 7 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you were arrested for driving while intoxicated June 21st of 2025. And is that true or not true?
True.
And then count 8 alleges that you are behind in your court-assessed fees as of July 17th of 2025 in the amount of $1,825. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 8 freely and voluntarily?
Yes.
And did you plead true to those counts because they're all actually true?
True.
All right.
Yes.
So I'm going to find that you entered your pleas of true to counts 1 through 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. However, it's my understanding that you've reached an agreement with the District Attorney's Office. Mr. Nichols?
Your Honor, our intent is to have her do 120 days, day for day, in the jail as a sanction, understanding that this is a rare opportunity. We're awaiting the resolution of her Orange County cases, that she would be on, no tolerance from this point on, and have to deal with Orange County however they see fit.
And Your Honor, she has been going out ever since she got out of jail on her own without any suggestion from me. She's been going to outpatient treatment 3 times a week, and she's got a job, and so even just going to follow. She did that out without talking to me. Just called me and said, "Hey, I'm getting some help." So.
All right. So it's your understanding that you'll go into custody, do 120 days, that you'll still be on probation, ordered to follow all the rules and conditions, including any others that I think are appropriate. Is that your understanding?
Yes, ma'am.
Then at this time, based on that, this is an excellent opportunity, Ms. Joseph, because the offense that you're on probation for, with a violation like this, you could go to prison for 2 to 20 years. So I want you to take advantage of this opportunity that you're being given today, because if you don't and you're back in here on any violations, it will likely not go this way. You understand?
Yes, ma'am.
So I'm going to, again, find counts 1 through 8 true. I'm not going to revoke your probation. I'm going to continue you on probation. I am going to extend your probation by 1 year. I'm going to order the 120 days as a condition, day for day, as a sanction for these violations. I'm also going to order that you're on 0 tolerance. So when you get out of the 120 days, you have to do everything right. You need to make some payments. You're getting behind on those. Follow all of the rules and conditions. I am going to order, since you're going to treatment, it obviously appears that there's an issue. So I'm going to order when you're out that you also enter and successfully complete the JCDI program. It's an outpatient treatment program. You'll be able to continue treatment, and hopefully you won't end up in a position like this. Do you understand?
Yes, ma'am.
All right, then good luck to you, ma'am. You can go with the bailiff.
Thank you, Your Honor.
Thank you. Thank you. All right, so Mr. Spites tested positive for THC, and so obviously sometime within the last 30 days or so, he's used marijuana, because typically that's how long, which means that he used marijuana after he pled guilty on a felony. He pled to an enhanced second degree. I've got pages of criminal history here. And you would think, Mr. Spites, that based on what Ms. Hawkins is telling me about your family situation and your children, that you would be able to figure this out on your own and stay clean so that you didn't, number one, go to prison. I don't even have to accept this plea agreement. I mean, you've got 3 prior convictions, a state jail felony from 2019, from 2019, credit debit card abuse from 2021, and then an unlawful possession of a firearm in 22. None of those cases did you receive probation, which is probably why Ms. Malfino made that offer to try to get you on the right track. And Ms. Hawkins did a great job of getting you a probation offer on your case or cases.
If I may,
Yeah.
part of the reasoning behind that offer that Ms. Hawkins and I discussed was that jurisdictional type issue that she addressed with the court, and also the fact that there ended up being no restitution that's owed to any individual.
Okay. And I appreciate that argument that Ms. Hawkins made, but it's also important, and I would hope that other judges in other counties would find it just as important, that if you're going to get charged, wherever you're going to get charged, that they take into consideration that just because you didn't steal from someone in our county, you stole from someone in some county, right? And so we got you here, but somebody's a victim. And it's important to me, and hopefully important to every judge in the state of Texas, that we kind of look out for each other in each other's counties. So I get that you were just traveling through, probably lucky that we got you, because who knows what would have happened at that point if you ever would have gotten caught. And that's not fair, no matter what county the crime is actually committed in. Does that make sense? Based on everything that is being offered to you and what the pre-sentence talks about with regard to drug usage, the only way I'm going to go forward with this is with some inpatient ISF up front. So it's not necessarily meant to be a punishment. It will probably feel like it a little bit, but if you're going to be successful in the rest of your life and be there for your children, then you got to figure out how to stay clean and make some better decisions. So that's what's going to happen today. Any reason not to go forward with sentencing at this point?
No, Your Honor. No, Your Honor. Just my only concern with that is the other pending cases in Fort Bend and Jackson County. I don't know if I simply take it.
What are the court, or do you represent them in Fort Bend?
Not
And
Fort Bend, Judge, no. I have his attorney's information up there.
and what about the Harris County,
I do represent
that
him.
evading?
I do represent him in Harris County.
I just don't, I'm trying to think of logistically, because one thing that I can do, I'm just not inclined to let Mr. Spites walk out today on a probation when he tests positive with this kind of history and with technically 4 felony cases pending in 3 different counties. So,
I have to ask Judge, my next question was going to be, is there typically a report date that could be given for ISF for the attorneys
No.
in for it?
no. And so what I'm going to do is I'm going to order it. And then once he's in custody, if you'll let obviously Harris County know that he is in custody. And if they will put a hold on him and come get him, I'll release the ISF hold while he goes and takes care of with that. Same thing with Fort Bend. But then if those are going to be probations or whatever happens, we'll put our hold back on once he's gone. So that when he finishes those counties, we've still got him for ISF. Sometimes what happens if that process takes a really lengthy time, then potentially if I feel like it's a good enough time, then I can hold that at abeyance at that point and require something like JCDI, which is outpatient. But based on the positive drug screen today and based on this criminal history and what all's pending, he's not walking out of here today. So we'll do it that way. If you'll get with his attorney in Fort Bend County, the sooner they get something set and get a hold on him, the better. Okay, that way he can get transferred, get those cases taken care of.
And I'll reach out to those DA offices, judges.
Perfect.
Maybe with the court's order, they would be willing to negotiate their
Something
cases.
quickly.
Yes.
So, Mr. Spites, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. I'm going to follow the agreement that you made with your attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine. There is no restitution. And you're ordered to enter and successfully complete. Mr. Spites, talk to her in a minute. Just listen to what I'm saying, okay? You're ordered to enter and successfully complete the substance abuse track of the ISF program. And if you do all of this, this is a great opportunity for you. I know it doesn't feel like it today, but you have a great opportunity in this case, number one, without another felony conviction, and to be able to serve any sentence while you're out on probation. I want you to make sure you understand, though, what the consequences could be if you violate this probation. So if you choose to smoke marijuana again or not show up for an appointments or whatever it is, then you're looking at not just a sentence of the theft of property, which is the 3rd-degree felony. You pled to an enhancement, which means if you violate, you could be found guilty and sentenced to prison for anywhere between 2 years and up to 20 years. So I'm trying to keep that from happening and give you some tools so you can be successful. I'm handing you the trial court certification that shows this was an agreement. I followed it, and so you've waived your right to appeal. You can back with the bailiff. Ms. Hawkins can visit with you back there, okay?
Can I ask you something?
Yes, sir.
Okay. The fact that, all right, y'all taking me in, that means like I can't get out from here. How can I get out so I can be able to handle Fort Bend?
We're going to let them know that you're in custody, and they'll come transfer you over there from our custody.
Okay, so that's what I'm saying. That's what I'm trying to understand. Okay, if I'm on bond with them, like how would that work?
Ms. Hawkins can explain it to you, okay? All right, you can go back with the bailiff. Thank you, Ms. Hawkins.
Ms. Spies entered court expecting probation, but a positive drug test changed the conversation concerned by his criminal history, pending felony cases, and recent marijuana use. The judge ordered him into a substance abuse treatment program before he could begin probation. While the plea agreement remained intact, the court made it clear that another mistake could expose him to a prison sentence of 2 to 20.